what aspects will you be dealing with, Mr.
My lord, I am dealing with the 3 or 4 aspects, my lord. One being on Nabam, my lord, very briefly, which is not specifically highlighted. Number 2, my lord,
42 pages.
Quixote para 122 with relation to 21B. And my lord, the 2 judgments which they have relied upon on the other side to contend, my lord, that there is a permissibility under the constitutional scheme for the court to deal with a disqualification petition directly. And the Karnataka judgment is, my lord, a Bible on not attending meeting constituting a disqualification under 21A. Lord, I'm going to, with reference to para 122 of Kyoto, it is only 2 kinds of meetings, my lord, which fall under 21B. This, my lord, the first point is, my lord, Nabam. And that, my lord, respectful submission is rule against participation of the speaker till the time, my lord, the removal resolution process is completed. My lord, if your lordship will come to the index, kindly skip the first one. My lord, there is a 1-page index.
Rule against participation.
So first point your lordship may skip on the relevant dates your lordships have considered, noted down. I am not reading anything from there. The first is rule against participation of the speaker. Kindly come to that at page 5.
Page 5.
And my lord, your lordship may take it, my lord. I am not reading anything unless, my lord, your lordships have not seen any part. Now, my lord, rule 181 is against participation of the speaker. 179 is removal. Now, my lord, my respectful submission is 181 is founded on the basic principle of conflict of interest. That where you are personally involved or your personal action is or activity is going to be considered, you should remain out. This conflict of interest, my lord, gets elevated to the level of constitutional adjudication. A conflict of interest at the degree, my lord, even in executive functioning, if you have to now test it for a constitutional adjudication, the level would be far higher. So, my lord, there is a dissent, my lord, intra-party dissent which can be shown. And, my lord, the rule against participation of the speaker. And, my lord, this became a question in the constitutional validity challenge which was laid before this honorable court in Kyoto. That intra-party dissent is also a part of the constitutional scheme as well as democracy. How do you create a balance? This, my lord, is laid down, and I made a submission earlier, my lord. The proviso to 179C is the beginning of that rule against participation. Proviso to Article 179C is the commencement of the time duration. I'm sorry.
No.
Yes.
Time duration of commencement of rule of non-participation, and it gets concluded in terms of the main provision of 179C when the removal resolution is considered in the House. Kindly have a look at that, my lord. 181(2) is rule against participation. This is my submission, my lord, based on the conflict of interest, and when it is to be tested in the touchstone of the constitutional adjudication, because clause 6 of the 10th schedule is constitutional adjudication by the speaker. Now, my lord, if your lordship may kindly see the next page, my lord, page 6 of my written note, para number 5, which reproduces the relevant portion of 179C.
Yes.
And I'm not going to read it, my lord. My respectful submission is that the proviso is the commencement of that non-participation period to begin, and main proviso to 179C is the conclusion when the removal resolution is taken in the House. Clause 11 from the legislature rule, Maharashtra legislature rules have been reproduced. I'm not reading it. I want to read, my lord, these 3 paragraphs again. From Justice Honorable Mr. Justice, as your lordship then was not Dipak Mishra Judgment, from para 235 to 238, which are reproduced at page 8 and 9. Now, my lord, when this conflict of interest is raised to the level of constitutional adjudication, and, my lord, the inter-party dissent is to be kept in mind, on the basis of which the validity of this entire schedule was upheld, 10th schedule was upheld. Kindly come to 235. The purpose of referring to the said article is to highlight the nature of participation of the speaker when the question of his removal arises. It is clearly different under the Constitution. He is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution and especially keeping in view the language employed in the first provision, Article 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest till the resolution is moved. Then 237. The aforesaid reasoning eloquently speaks of the power, position, and the status of the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and it is restricted it to the state, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority, jurisdiction, exercise the power of constitutional adjudication. The concept of constitutional adjudication as constitutional value in a parliamentary democracy and constitutional value sustain the democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. The Speaker, when functions as a tribunal, has the jurisdiction, authority to pass adverse order. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of 10th schedule by constitutional amendment is required to be harmoniously construed with Article 179C. Both the provisions of the Constitution are meant to subserve the purpose of sustenance of democracy, which is a basic feature of the Constitution. Manurula, we are speaking about democracy as opined that democracy in India is a product of rule of law and it is not only a political philosophy but also an embodiment of constitutional philosophy. Thus, regard being had to the language employed in Article 179C of the Constitution and the role ascribed to the Speaker under the 10th schedule, it is necessary that Speaker as a tribunal has to have complete detachment and perceivable impartiality. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of Article 179C, and the said interpretation serves the litmus test of sustained democracy founded on rule of law, and the founding fathers had so intended, and the constitutional value, trust, and morality unequivocally to suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the 10th schedule to the Constitution after intention to remove him from office is moved. The 14 days period being mandatory, the words all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command is to have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution, and it clearly brings in harmony between constitutional confidence or trust and the constitutional control. Be it stated, the position has to remain the same even after introduction of 10th schedule to sustain the robust vitality of our growing constitution, and it embraces the seminal spirit of rule of law that control all the powers, even the prerogative powers. So, my lord, therefore, this is how, my lord, the court brings in a balancing between these two, my lord, apparently areas which may be in conflict with each other, but your lordships, my lord, brought an interpretation to ensure that it is a smooth functioning. Now, my lord, this is founded on the principle of elimination of conflict of interest. And, my lord, that conflict of interest, when it is required to be demonstrated in a process of constitutional adjudication, your lordships laid down the duration of rule against participation of the Speaker, from the date of issuance of that intention of notice of moving the resolution and its completion when the resolution is moved, and my lord, whether it is sustained or it is not sustained. So that's the first respectful submission, my lord. Does not require any fresh look because the reasoning is very, very sound, my lord, and is based on the principles which have stood the test of time. Now, my lord, if your lordship may then come to kindly move a little ahead on the next part of my note, my lord. My lord, Rana was pressed time and again with utmost respect to the other side. Please see Rana. Rana is a judgment which clearly reveals and clears the way for entertaining a disqualification directly by the courts. My lord, Rana is a case, my lord, and I will only make one line submission here, which has also been made earlier. The original disqualification petition is considered by the speaker. It is then met a fate of its non-sustainability by the High Court. The matter when came to your lordship, no, your lordship then said now there is no need to remand and we will rule on it. To rely on this judgment to say no, it gives a permissibility to the other side to raise a submission that the speaker's jurisdiction should now get vested with the courts and courts should come under an obligation to consider such a petition at the threshold. My lord, is not permissible. It, my lord, it would not deserve any approval by your lordships. My lord, page 13. There cannot be and should not be any deemed, my lord, disqualification. My lord, civil consequences, compliance with principles of natural justice, prejudice caused on the removal of an elected member of the House. My lord, it would be, with utmost respect to my friends on the other side, would be preposterous to even suggest that when a particular action can have such consequences that you remove an elected member, inflict an election again on the same constituency. Can there be that there is no notice and hearing? Because, my lord, to say that there is a deemed disqualification is making a submission of complete elimination of any process to be followed before giving that, my lord, position. No process to be followed. If a gentleman, according to that test, commits an act, he must go home straight away, whether elected by a constituency of, say, 20 lakh people. My lord, MP constituency now between 16 to 20 lakhs. So the expression of their will toward the democracy must suffer a deemed removal, a negation totally, or totally unknown to any civilized society norms. Forget the constitutional scheme. The suggestion itself, mother, with utmost respect, is preposterous. Should not deserve, my lord, even to be entertained as an argument. And, my lord, only thing which I want to rely additionally, a judgment of 3 judges, my lord, of your lordships, which I have cited, my lord, at page 13, para 7, where, my lord, leading evidence in a 2-1A petition, your lordships have remanded it back that full opportunity, including leading of evidence, would flow from 2-1A. My lord, this is 2022 2 SCC 759. A short judgment, my lord. I'll leave the copy with your
Manipur judgment.
I'm sorry.
Manipur judgment.
Yes, my lord. Now, my lord, after that, I want to read 122 in this background, my lord. We start from page 14, 122 of Kyoto. My lord, intra-party dissent was one of the argument to, my lord, to establish unconstitutionality and invalidity of the 10th schedule. That one of the rights of elected candidates is to speak against their own party if need be. That itself is a part of democracy. That how much I can speak on various large public interest issues within my party or outside against my party. Can this be curtailed totally in the name of party discipline and embarrassment to the party? Can it be curtailed totally? Should it be eliminated? My lord, your lordships upheld the validity and kindly make a note of para 44 of Kyoto, 17, 44, 121, 122 and 123. Let me repeat, my lord, 1744, 121, 122 and 123. Now, my lord, your lordship may also make a respectful, kindly consider a respectful submission. If your lordship may kindly see clause 2 of the 10th schedule, which is reproduced at page 14. My lord, the grey area now only remains is 21A. 21B, your lordships have decided in Kyoto 122, and I am going to read it, my lord. My lord, your lordships have dealt with this matter even in the 239 AA first round of the Constitution bench. Any and every direction. What is the meaning of any in such constitutional provisions? Kyoto, my lord, is relied upon in the 239 AA by your lordships. In paragraph, it says, any can't mean every. Number 21B uses the word any direction. Kindly have a look at 21B. If he votes or abstains from voting in such house, contrary to, please mark the next word, any direction. So the argument raised was, wherever any is, it would include every. Any has no other meaning but to be every. So this was pressed into service that the language is so clear. How can this be curtailed?